Hi, welcome back. Attorney Steve Ondren. We are talking in this video about privacy torts, California law. We are talking about, there are 4 privacy torts in California. So if you're taking the bar exam, you got to know these torts. One of these is probably going to come up. They're very topical with the internet nowadays and things that can be posted on the internet in particular. So we're going to talk about intrusion on private affairs, also known as intrusion on seclusion and solitude. Intrusion on seclusion and solitude, or private affairs as we call it. So without further ado, let's take a look here. This is the jury instructions, CACI 1800, intrusion into private affairs. Here's California privacy torts. Let's go down and take a look at the elements a plaintiff will have to prove if they've tried to bring a privacy claim in the state of California. So this is a tort. This is one person or one company doing something wrong to another person or another company. Civil litigation, okay? At any rate, plaintiff claims that the defendant violated his or her right to privacy. To establish this claim, the plaintiff must prove all the following. So this means the burden of proof is on the plaintiff to prove each of these elements. There's 5 elements by a preponderance of the evidence. If you can't prove even one of these, boom, you got no cause of action, you lose, case over, waste your time, waste your money. So you want to make sure before you're filing these suits that you have all your ducks in a row, that you can allege and hopefully plead and prove each of these allegations. Okay, 1, defendant had a reasonable expectation of privacy in some place or circumstance, so you need to be able to have a reasonable expectation of privacy. 2, defendant intentionally intruded, can't be accidentally walking in or do it, has to be intentional intrusion. 3, defendant's intrusion would be highly offensive to a reasonable person. Talk about that in a second. Number 4, the plaintiff was harmed. There has to be some kind of harm, okay, like some sort of mental, emotional damage, financial damage, some kind of damage that the law would consider to be, something more than de minimis or trivial, okay? And 5, defendant's conduct was a substantial factor in causing the plaintiff's harm. So sometimes you have multiple defendants. You need to be able to show each one was a substantial factor in causing the plaintiff's harm. So let's take a look at that. Actually, and let's go down real quick because I'm going to talk about what is a reasonable expectation of privacy and intrusion being highly offensive to a reasonable person. These are the 2 tough ones, okay? So these are the things you have to get to. So let's come down in deciding whether or not a plaintiff had a reasonable expectation of privacy. You should consider the following factors: the identity of the defendant, the extent to which other persons had access to or could see or hear the plaintiff, the means by which the intrusion occurred. Okay, so these are the 3 things you're looking at to determine whether or not they have a reasonable expectation of privacy. Okay, in determining whether an intrusion is highly offensive to a reasonable person, remember that was the other requirement, you need to look at the extent of the intrusion, the name of the defendant's motives and goals, and the setting in which the intrusion occurred, okay? So those are your basic elements. That's what you're going to be wanting to think about before you file these lawsuits. Also, you need to be thinking about the defendant and what they're going to argue, okay? So a big one is that there was consent to it, or that the First Amendment allows this, for example, in news gathering informations, click, 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 the paparazzi coming into somebody's bedroom taking pictures, there's a difference between being in their bedroom and being out on the street, okay? So let's go back and take a look, and I'm going to apply a case here so you can get a better understanding of how this works. But there was the Hulk Hogan case, and I believe this was a Florida case, but there was the Hulk Hogan case where he was the big wrestler. I believe it was the World Wrestling Federation, I believe. He was kind of the spokesperson of that. So what happened, he had a friend named Bubba the Love Sponge. What a name. Bubba the Love Sponge. And Bubba had a wife, and somehow they worked out some deal where Hulk Hogan got to sleep with his wife. But what they didn't tell Hulk Hogan is that they were going to be videotaping it. So he was videotaped having sex with the guy's wife. The video surfaces, somebody sends it to Gawker.com, Gawker Media. Gawker Media says, whoa, this is Hulk Hogan. This is a big story. Oh my gosh. This is First Amendment newsworthy. What a story. Well, Hulk Hogan got wind of it, and he saw that there was, I think there was a minute and a half clip or so that was posted. There was more to the tape, apparently, that he did not want to come out for other reasons I'm not going to go into. You can look it up online if you want. I don't like to go into that kind of stuff, but he found out about it. He hired an attorney. The attorney sent a letter to Gawker and said, look, do me a favor, just take the darn video down. That's it. We'll go away. We don't want money. Just take the damn video down. Gawker Media said, no, we're not taking it down. This is newsworthy. It's the news. First Amendment right, freedom of the press, okay? Or, something along those lines. At any rate, the case went on. They tried it. Both parties got entrenched. They took it to trial. The jury awarded over $100 million. Over $100 million to Hulk Hogan. The case is now up on appeal, but this was just a gigantic case centering under the right of privacy, intruding into private affairs. So if you look at it, did Hulk have a reasonable expectation of privacy in the bedroom? Probably, right? You're in a bedroom, you think you're kind of private. I would say yes, you probably think that there is a expectation that that would be a private. You're not doing it out on a balcony somewhere, something like that. There was an intentional intrusion. There was a video camera that was obviously set up to capture that moment. Would the intrusion be highly offensive to a reasonable person? Well, ask yourself, if it was you and you woke up one day and you saw that on the internet, would you go, ha ha ha, that's pretty funny? Or would you go, oh my God, I can't believe it. This is so offensive. Oh my God, it's what a reasonable person would do. Is it objectively reasonable that this would be highly offensive? The jury said yes. Was plaintiff harmed? Yes. He had ultimately had lost his sponsorship with the World Wrestling Federation, I believe it was. So he had emotional harm. He had lost money damages, things like that. So, that's just a whopping verdict. It's up on appeal. It may get cut down on appeal. Lots of times on appeal, things get cut down, but we'll see. And so that's about it. And so we had a big name defendant. You had, the bedroom was not someplace that was open access for the news media, and the intrusion was something he wasn't aware about. So really, these cases where you have celebrities that sort of rely on the media and made their name on the media, people tend to think, well, this is newsworthy because it involves Hulk Hogan. And in the trial, he said, well, look, there's Hulk Hogan and then there's me. Hulk Hogan is my character that I play, but there's also me. So the jury said, yes, this was privacy. Privacy rights outweighed any First Amendment interest, although I think probably a lot of people would watch the video, and I think a lot of people did, as the video was also posted on porn sites, porn tube sites, and things like that. So there was a lot of interest in it, but there was a lot of privacy interest. So in these cases, you can see a balancing, and you don't want to be on the wrong side of that scale because you can see, that can literally wipe out a business. So that's some general legal information about one of the torts of privacy. We're also going to be talking about the other three: publication of private facts, right of publicity, somebody using your name, image, or likeness without your consent, and what's the other one? Intrusion on seclusion and solitude, and false light. So putting someone in a false light, basically attributing things that aren't true. So that's it on this video, Invasion of Privacy. If you need help, entertainment law, copyright, intellectual property, you know where to find us. AttorneySteve.com. That's AttorneySteve.com, the first name in legal services. We are licensed to practice law in California and Arizona. We have offices in San Diego, Newport Beach, Santa Monica, and San Francisco, and an office out in Phoenix. So if you need help, civil litigation, arbitration, cease and desist letters, those kinds of things, you know where to find us. Make sure to subscribe to our video, punch that subscribe button. Hit the little bell too, that little bell, that'll tell you when new videos are coming out so you can watch them fresh off the press. I like to bring that fresh law to y'all. So that is one of the 4 privacy torts in California: intrusion on seclusion and solitude, also known as private affairs. Stay tuned, the other ones are coming shortly. Gotta go, bye now.